Broadcast is now starting. All attendees are in listen-only mode.
Good afternoon. This is Patricia Scott and Scott Chernich on the part 2 of Collect Your Money in Bankruptcy. The session today is going to be on Chapter 13, even though the material that was produced said Chapter 11, so we apologize for any confusion. The Chapter 11 component will be covered on November 18th, so you can tune back in then and hear about Chapter 11 on November 18th. Today we're going to talk about Chapter 13. And at any time, you can submit questions via the online view that you have, and then we can answer those as we go along. So in Chapter 13, if you were here last time, we talked about Chapter 7 and how Chapter 7 is a straight liquidation. And bankruptcy is covered by the federal statute and applies in all states. And as we discussed, the basic chapters are 7, 9, 11, 12, and 13. And as I said, today we're going to talk about 13. Chapter 13 is a reorganization chapter that involves a repayment plan. And in that regard, Chapter 13 is much different than in Chapter 7. Under Chapter 13, the debtor files a plan of repayment in addition to the statement of financial affairs and schedules of assets and liabilities like they would in a Chapter 7. The Chapter 13 plan is what provides for repayments to secured creditors and a payout to unsecured creditors. A Chapter 13 trustee monitors the plan. There is limited eligibility for a Chapter 13. Chapter 13 debtors must have unsecured debt of less than $383,000 and some change, and secured debt of less than almost $1,500,000.
You can finish that off. Go ahead.
Okay. If the debt exceeds that limit, then the debtor has to go to a different chapter, probably a Chapter 11.
All right. Let's. I think it's important to back up here just a little bit. This is Scott Chernich, and just go over or review the title to the Chapter 13, which is reorganization of an individual with regular income. We may cover these issues in the future, but it's important from a conceptual standpoint to think about what that means. And what that means is it's an individual. Obviously, it can't be a corporation, partnership, or anything other than that. And it's a reorganization. Tricia already covered that, meaning that we're going to repay creditors. It's not like a Chapter 7 where there's a total liquidation. It means we're going to repay creditors. And the third component is with regular income. There's some case law out there about what constitutes regular income, but essentially what it means is that you do have money coming in every month so that you can pay the plan according to its terms. So just from a broader perspective, it's better, or it's helpful to think about this in the terms that are used in the code that tell you what it is. So reorganization of an individual with regular income, those are all important.
So really the basic concept of a Chapter 13 is that the debtor must dedicate all of his or her disposable income, which is really income over normal reasonable expenses, to the repayment of creditors. And the creditors must also receive more than they would if that debtor had filed a Chapter 7 liquidation.
Yeah, so here, the idea, if we can go back one screen, Trish, we breeze over these things because we're lawyers used to dealing with this, and so the concept here is that the debtor is going to dedicate all of his or her disposable income. What that means is that there are allowable expenses. This is kind of a weird concept in the bankruptcy code, but allowable expenses are those that the IRS allows for debtors or people that owe the IRS money to deduct, and it's calculated by region. And so when the IRS is determining whether or not somebody is making an offer in compromise to say to pay taxes that they owe, then the IRS looks at where you live and then they make deductions for certain things: housing, car, food, all those types of things. So in figuring out what disposable income is, you take the allowable IRS deductions for living expenses, and then take that out of what the take-home pay of the debtor is, or whatever the debtor's regular income is. And so the difference there is what we call disposable income, and that has to be dedicated to the plan for the entire life of it, typically 5 years.
And in exchange for dedicating all of that future income, the debtor receives a discharge from what would otherwise be non-dischargeable debt. The debtor also has the opportunity to buy out equity that a trustee would otherwise reach for creditors. Typically, that happens in a Chapter 7. And as Scott said, the plan is typically 5 years, 60 months. In some instances, if the debtor's disposable income is very low, then it may be that it's only a 36-month plan, 3-year, 36-month. Just a brief overview of the players. We talked about this last time if you were in on the Chapter 7 discussion. The players are pretty similar. In a Chapter 13, we have a trustee who is, the role of a Chapter 13 trustee is quite a bit different than a Chapter 7 trustee, and that the Chapter 13 trustee is chosen from a panel of private trustees in the district. And oftentimes, a Chapter 13 trustee, there's only one for that district unless it's a very large district. And that trustee, of course, oversees the plan and makes sure that the debtor makes the payments into the plan as the debtor is required to do. The debtor, of course, is the one who owes the money, is the one who filed the bankruptcy petition and filed for relief. And the debtor's obvious goal in the whole proceeding is to be relieved of debt and to receive a discharge.
Okay, let's go back to two other concepts, if you would. The first one is this idea of disposable income. I wanted to go back to that because while you were going on, I thought of this. Disposable income is like what I said before, allowable expenses taken from your income. It also means that if the debtor experiences a windfall, in other words, they get a bonus in their pay, they get tax refunds, they get anything that increases their income for the year, that amount of money has to be put back in the plan. And typically it has to be accounted for at the end of the plan. So surprise, surprise, what happens to a lot of debtors is they get to the end of their plan, they're trying to get out of bankruptcy, and the trustee says, you got a tax refund 2 years ago for $1,200, fork it over. And so that can be a surprise at times. The other thing I wanted to talk about, and some of these things go without saying, but in any system like a bankruptcy case, understanding what the motivation behind people is key. And so I don't like Rush Limbaugh, but he does say one thing, which is follow the money. If you follow the money, you can figure out why people do things. So a Chapter 13 trustee is a standing trustee. They make a percentage, 6% of the money that flows through their office. Now, the trustee doesn't get all 6%. The trustee is limited to how much he or she can make. It's a percentage of what a bankruptcy judge makes. In other words, you can't insult a bankruptcy judge by paying the trustees more. So they're limited to less than what a bankruptcy judge would make. And of course, bankruptcy judges make less than district court judges, and district court judges make less than circuit court judges, and circuit court judges make less than Supreme Court judges. So it's all a hierarchy. And so Chapter 13 trustees are limited to what they can get. Now the whole 6% though goes into the operation of their business, meaning this whole thing of taking money in and paying it out. And they have a lot of staff members. You can imagine they've probably got, I'm just guessing here, but anywhere from 5,000 to 10,000 active cases where they have to take money in and pay it out on a percentage to each creditor. That takes a lot of work. It takes a lot of staff, and it takes lawyers. So the Chapter 13 trustee hires lawyers that are usually employed in his or her office, and they also have staff members. So the 6% goes to that operation of the business, and then to the trustee's salary, which is limited. And so the trustee doesn't have a vested interest in taking more money off of people. He or she's limited to what they can take in. So remember, follow the money.
And as creditors, there's obviously two different types of, well, technically, I guess there's three different types of creditors. There's the secured creditor who holds a claim that has a lien on property with value to cover that lien, at least in some part. There are unsecured creditors who either, maybe have a judgment or a guarantee from somebody who is just a guarantor, and there's no lien or collateral to support that debt. Unsecured creditors have the lowest priority. I guess a third type of creditor would be an administrative creditor, a creditor that's owed money that has priority, and they have one of the highest priorities. And as we talked about last time, state law does come into play. Even though bankruptcy code is governed by federal law, Article 9 UCC is a state, it's adopted in all 50 states. Each state has it, and it is state law, and it governs property rights and lien rights that creditors have. And those will apply in the bankruptcy case and in essence follow through the bankruptcy as it goes along.
Well, Tricia's pointing at me to tell me that it's my cue to talk at this point. The issue here is that whatever a creditor's rights are under state law doesn't change in a bankruptcy case. And so if you have a security interest that's perfected pre-petition, it's a pre-petition debt, pre-petition perfected interest. That interest flows through the bankruptcy no matter whether they filed or not. If that didn't happen, you can imagine that would set the whole system on its head, because we could undo security interest and all that. Doesn't mean it can't happen, but generally speaking, those rights that a creditor has pre-petition are the same rights that they have post-petition.
Thank you, Scott. And as a lien holder, you're required to get notice of actions that can affect your lien. So if you are a secured creditor and you have a lien in property that the debtor owns and the trustee wants to take action against it, you are going to receive notice of that. But it's important that you act upon that. If your rights are being diminished or lost in any way, you need to respond and object so that your rights are not reduced. Judgments and mortgages are really the same way. Since state law governs the creation of liens on property, including real property and judgments, mortgages, and other liens, it's important to consider that even in the bankruptcy context, those rights are going to continue, but you must monitor them. And that brings us to Chapter 13 as a whole, and the Chapter 13 plan as it's filed, and what you need to do when the debtor files a Chapter 13 plan.
So here, the plan must meet certain tests that the last screen said at the bottom. In this fashion, or in this regard, every district has its form Chapter 13 plan, or what they call a model Chapter 13 plan. And so it's important because, as you can imagine, there's not a million, but thousands of bankruptcy lawyers out there. If they're all doing their own plans that don't meet a model, then you'd have to search through every plan to figure out what's going on. And so to short circuit the problem of Chapter 13 trustees trying to figure this out and all of their staff figuring it out, every district has come up with their model Chapter 13 plan. So you can't, every part has to be in the same spot. So you can't hoodwink a trustee or hoodwink creditors. You know where it's going to be. Turn to page 5 and you can see where secure creditors are going to be. You can turn to page 7 and see what the budget is. So it's routine and repetitive, and everybody's operating on the same playing field.
And as we discussed, the debtor has to commit all disposable income into the plan and pay creditors more than they would get in a Chapter 7 liquidation. And you receive notice of the Chapter 13 plan, and you have to object in a timely manner if your rights are being affected. Mostly that's going to be as a secured creditor. So as Scott stated, in the same spot in the model plan for the district in which you're in, a secured creditor is going to be listed if it's real property or if it's a vehicle or an RV or something. There's going to be a section and it's going to state how much is going to be paid, what interest rate it's going to be paid at, and if there is an arrearage, whether or not that's going to be cured and how. And if you just, go ahead, Scott.
Yeah, I just wanted to back up one slide. One of the requirements is that in a Chapter 13 case, the debtor pays more than in a Chapter 7 liquidation. That everybody breezes over that, but what does that mean? And what it means is that you take the debtor at the moment they file their Chapter 13 case, and then you perform what's called a hypothetical liquidation. We take what they have, give them their exemptions, what they can keep, and then essentially sell whatever they can't keep. And so say that generates $1,000. That means that in that Chapter 7 hypothetical liquidation, we'd have $1,000 to give the unsecured creditors. So in the Chapter 13 case, they have to pay at least $1,000, right, to be able to be in 13. Otherwise, why would we want them there?
Good point. So when you're looking at a plan, the first thing you want to do is determine if your security interest is properly provided for. If you're not listed there at all, it may be that the debtor intends to surrender that collateral, or it may be that the debtor has not listed it at all, and you have to file an objection to make sure that you are properly provided for and that you're not impermissibly crammed down. Some instances, a cram down is going to be permitted, but in several instances that we'll talk a little bit more in a little bit here, cram down is not permitted, especially when it comes to the debtor's principal residence, if you have a mortgage on that, or if they've bought a vehicle within the last 910 days.
All right, so in talking about this, everybody breezes over this term cram down too. It's one of my pet peeves from teaching bankruptcy law for so long. Really what it means is that the debtor is trying to strip the lien. And what that means is, say you have a debt of $15,000 and the vehicle's worth 10. What they want to do is strip the lien down from 15 to 10 and pay you 10 on the secured portion of the debt and pay you out on the $5,000 unsecured portion like every other unsecured creditor. The vehicle may not be a good example for reasons we'll talk about later, but they can try and do that on any other piece of collateral other than a principal mortgage or a car that's not been bought within 910 days. So you have to be careful about how they're treating your collateral and what they intend to do with it. That's the most important thing.
The other thing that's interesting too is all creditors in the same class have to be treated the same. And what do we mean by same class? We mean if you're secured by collateral, then you're going to be in the same class. You're going to be in the same section of the plan, if you will. If you're an unsecured creditor who doesn't have any collateral to support your debt, then you're going to be in the unsecured section of the plan. And all unsecured creditors are going to get the same pro rata share, whatever, if it's pennies on the dollars, or if you're fortunate enough and it's 50 cents on the dollar, you're going to all be treated the same. And that's important to make sure the plan provides for that. The Chapter 13 trustee is also going to be monitoring for that, but that's something that to protect your own rights, you should monitor that as well to make sure you fully get paid what you're due in comparatively to other creditors. We've already discussed that a plan is typically 36 or 60 months, depending on the factors and the tests that the debtor has to complete before filing the Chapter 13. And your objections must be timely made. If you do not object and the plan is confirmed, you have lost the right to object. So what do you do when the debtor files for a Chapter 13 and you receive that notice in the mail? The first thing you have to do is, much like in the Chapter 7 case, the automatic stay is in place and you have to stop collecting against the debtor. And the Chapter 13 is a little bit different than a Chapter 7, and you also have to stop collecting against co-debtors, regardless of whether that co-debtor filed for bankruptcy. This is only an instance of when the debt is a consumer debt. So if this debt relates to the sale of goods for a business or it's commercial and related, this rule doesn't apply. But in most instances, if the debt, is a credit card and it's for, just a regular residential type debts, household goods, that kind of thing, you need to stop collecting against the co-debtor as well. And then the next thing that you're going to do in a Chapter 13 is you're going to automatically file a proof of claim. In a Chapter 7, you wait to see if the trustee sends you a notice to file a proof of claim. But in Chapter 13, it's automatic because, as we've discussed, there has to be a larger payout to creditors in a Chapter 13, all creditors, even unsecured, than would be in a Chapter 7. So generally, there's going to be some form of payout. It's very rare that a Chapter 13 isn't going to have a payout to unsecured creditors. So you're going to file that proof of claim within the deadline set by the court, which is generally 90 days after the date the debtor filed for bankruptcy, not the date they filed their plan or the date the plan was confirmed, but within 90 days, that the debtor filed for bankruptcy, and that would be on the notice that you receive that the debtor filed for bankruptcy. And filing proofs of claim in Chapter 13 are a little bit more complex as well. There's official forms, and you can find those on the court website, or in regard to Chapter 13, you may want to seek counsel's advice and assistance in filing for a proof of claim, because an itemized statement has to be attached showing all applicable interest, fees, expenses, or other charges that have been incurred. So when you file that proof of claim form, you not only have to fill out the form, you have to attach an itemized statement showing all of those other charges and your documentation to support your claim. If the debtor's, if your claim relates to the debtor's principal residence, unfortunately, it gets much more complex because there are several other forms. The rules were changed in 2011, I believe, and the forms are about to be changed again of December 1st of this year, and they're going to add another form. So there's an additional 3 forms that have to be filed when you have a claim against the debtor's principal residence and that debtor's in a Chapter 13. The first form.
Wait, hold on a second. We just breezed over that a little bit, but all of the bankruptcy forms, when I say all, I mean all, 92% of them are going to be changed as of December 1. So whatever you may have been used to using in the past is going to be radically altered. And it mostly will be radically altered in the sense that the instructions are different, the actual presentation of the document will be different. It's supposed to be more user-friendly, supposed to be easier for people to do themselves and that kind of thing. So everybody's got a great deal of trepidation about this conversion on December 1 of all the new forms to be used. So just be advised that if you have forms that you've been using and you might retain them in your own computer systems, those are not going to work anymore. They're going to be rejected by the bankruptcy court. So use a lawyer.
Yeah, when it comes to Chapter 13, it's really almost necessary. You know, Chapter 7, sometimes it's easy to fill out the form and put in your documentation and submit it. But when it comes to Chapter 13, that's not the case, especially if it's a principal residence. Along with your general form, as we were saying, you have to file the mortgage proof of claim attachment, which is a form that's been created that has to be filled out and all of the proper amounts filled in. And if there's an escrow account, there has to be an escrow account statement that is attached in addition to the typical documents that support the claim, such as the mortgage. And it gets really confusing if the loan is in arrears, because a statement of the amount needed to cure the arrearage has to be filed as well, and that amount is calculated as of the date the debtor filed for bankruptcy. And then you also have to go back to the to the plan. And as a creditor, you almost have 2 different claims at that point, because the debtor's going to be paying you on a going forward basis on that mortgage. And then the debtor's also going to be paying you on the arrearage, and they have to pay that arrearage within a reasonable amount of time. Probably not as quickly as you would like, but they do have to pay it within a reasonable amount of time. And that proof of claim has to make it clear to the trustee and to the debtor on what exactly it takes to cure that arrearage. And that's not always just mortgage payments that are past due. It may be that you started foreclosure and you have fees, you have publication costs, you have attorney's fees. All of those can be listed in there as part of your arrearage, as long as you list it properly and you have documents to substantiate those claims.
So what effectively happens, and it becomes difficult for creditors, especially financial institutions, is that in your own computer systems, you'll have a debt and you'll have accruing interest and other charges, but essentially you have one account. And what happens when the debtor files a bankruptcy petition, there's secured collateral, especially a mortgage. Essentially what the court is asking to be done and what the creditor has to do is now divided into a number of different subcategories. The arrearage as of the time the debtor filed, what they're going to pay in the Chapter 13 case, and then other charges. So it makes the creditor have to do a lot more work to reconcile what it is they're charging and expecting to be paid, and you have to verify that and make sure that the court and the trustee knows exactly how you get to those numbers. So it makes it way more difficult to collect in Chapter 13 than just the standard get the mortgage payment paid against what's due and owing.
Yeah, and it's not on.
By the way, Trish is an expert at this. I'm not the greatest because I don't do the detail, but Trish is an expert at this. She's looked into this and figured it all out on behalf of a number of different financial institutions, and it's super important because if you don't do it right, your claim can be reduced or disallowed to some extent.
Exactly, and in fact, at the end of a Chapter 13 plan, the rules now provide that the trustee has to issue what is, I think it's called a statement of completion. That may not be the exact name, but it basically says that the plan is complete, all payments have been distributed, and you've been paid in full. And then you have an obligation, if your claim is against the debtor's principal residence, to go back to those records that have maybe been difficult to keep, but you have to go back and make sure that you really have received all your money. And if you haven't, you have to file an objection to that trustee's statement of finality, basically to say, this is not final, this is not done, I have been paid in full, and here's why. So if you haven't kept good records, then it's going to be difficult for you to be able to file that objection, which actually you're probably going to have an attorney file it for you. But you're going to have to be able to provide your attorney with those documentation that says, look, we received these payments, we applied them this way, and this is still what's left over. So that's why it's really important to be able, from the start, to properly document what your claim is, and then to document as those payments come in. And then oftentimes when there's a variable interest rate, or when there's an escrow account, the mortgage payment is going to change. So in a Chapter 13 plan, it says the debtor is going to pay whatever the current plan payment or the current mortgage payment is over the life of the plan. Well, what happens when the bank or the financial institution conducts a escrow analysis and the payment goes up or down? That's okay, and that's permitted. But now there's a new form that you fill out that says that the principal resident mortgage payment is going to change, and here's what it's going to be. And that form has to be filed within 21 days before that new payment is due. So that tells the trustee or the debtor, whoever's making the payment, okay, so the next time I make a payment, it has to be for this amount. And additionally, you have the right to collect post-petition fees and expenses. Your attorney's fees are going up. You've got your attorney doing all this great work for you, and you want to recoup those costs. So you file a notice of post-petition fees and expenses. Maybe you've done an appraisal on the property too. That notice has to be filed within 180 days of the fees or expenses being incurred. So basically, you're going to want to file that notice every 180 days if you want to recoup those costs, which your loan documents probably provide for. You just want to make sure that the document properly gets filed. And if you are secured, get your proof of claim filed early, because sometimes the trustee will send out payments for adequate protection prior to the plan being confirmed. But the trustee cannot do that if you don't already have a proof of claim on file. And again, those are things that we can discuss further with you if you have questions.
One idea here is, and most don't know it, and in the Eastern District they might not enforce it, but when a debtor files a Chapter 13 case, the requirement is that they file the plan with the case itself. So they're also supposed to make payments, begin making payments the moment that they file. So the trustee may be getting money and no proofs of claim, and the money just sits there, and you could be getting your adequate protection payments and be on your merry way. But if you don't file that proof of claim, you don't get the money that the debtor's supposed to be paying to the trustee in advance of the confirmation hearing. So a little known fact, they're supposed to file that the petition and the plan and start making payments, all of the above. So if they're not doing any of that, then come see us.
Yes, and the general idea behind that is so that the debtor doesn't get even more behind than what the debtor already is. So that when that plan's confirmed, they're still, they're not already in the hole. So we were talking about what do you do when you receive notice that the debtor filed a Chapter 13, and we talked about stop collecting because of the automatic stay. We talked about filing the proof of claim. And then we've talked a lot about the plan, so you want to review the proposed plan. The debtor generally files that plan within days of filing bankruptcy. So it was probably filed sometimes concurrently with filing the schedules. it's a good idea to have counsel review the plan because the debtor must be paying in all of disposable income. And there may be objections that can be raised, even if you're only an unsecured creditor, because the U.S. Supreme Court has used terms that the debtor must tighten their financial belt. Debtors are allowed, as Scott mentioned earlier, to have certain amount of expenses. Those are called reasonable expenses that the IRS has determined. But the debtor can have a $250 cable plan or $250 cell phone service plan, things that are considered to be unreasonable. So if those things are included in what the debtor considers to be their reasonable expenses, then that obviously reduces the amount of disposable income that can be paid to creditors. And we can object to that and argue that that money should be going to creditors instead.
There's a lot of room there for negotiation and or objection. I see in plans and or in bankruptcy cases that people include in their allowable expenses anywhere from $250 to $500 a month for college expenses of one of their no longer minor children. And that's one example where you can object, and $500 a month over the life of the plan is a significant amount of money. We're talking $6,000 a year times 5 is $30,000. So you can increase the payout on all of the unsecured debts. Remember, you're going to participate with everybody. So to the extent that you may be objecting, you're going to be helping everybody out, not just yourselves to some extent.
But depending on the amount of your claim, it may still be very beneficial to go through that process.
No, absolutely, but it doesn't all go to you.
And as we discussed, the discharge doesn't occur in a Chapter 13 until the plan is complete. We discussed briefly how there's different forms that are going to be filed that will signify that we're coming close to the end. The trustee will file forms, and then there's going to be, a request for discharge at that point. So keep in mind that you cannot collect against the non-filing co-debtor until the case is closed or the debtor receives a discharge. And in a 13, that's going to be for the entire life of that Chapter 13. And remember, you're only entitled to one satisfaction. So if you do by chance, especially if you're an unsecured creditor, you get paid in full in that Chapter 13, then there's really nothing for you to go after the non-filing co-debtor on. But if you weren't paid in full, the debt was crammed down and it was permissible, and the end of the 13 comes, it's closed, the debtor receives a discharge, and you're still owed X amount of money, you can go after that non-filing co-debtor for the remainder of what you're owed. There are certain instances when filing a motion for relief from stay may be beneficial. It's unusual in Chapter 13 because typically the plan is going to provide for any secured debt, but there are instances where you may want to consider filing a motion for relief from stay on secured debt to recover the collateral. In particular, when the debtor is surrendering the collateral, if it's a vehicle that they're significantly underwater on, or maybe it's an RV or something that they don't think they're going to be allowed to continue to keep because the trustee or somebody may argue that it is a luxury item, then you're not stuck waiting for the plan to end. You can have counsel file a motion for relief from stay for you so that you can get your collateral. You're never going to be able to collect money, but you can at least recover your collateral.
So we have a question. And the question is, what is the benefit of filing a Chapter 13, and why wouldn't you just file a Chapter 7 and not have to pay anything back? It's a good question, and so the answer is a debtor's in a Chapter 13 case because they're forced to be in a Chapter 13 case. They're forced to be in a Chapter 13 case because, remember, if we take their income and deduct their allowable expenses, there's disposable income. If they have more than $167, weird number, $167 of disposable income, more than that, then they have to be in a Chapter 13 case. So as you can imagine, every time that you get a Chapter 7 case, their income actually meets their expenses almost to the dollar, so that they won't be in a Chapter 13 case. So the answer is they're forced into that position. You can say it's more laudable, or the reasons are more laudable because they want to pay people back, and in some circumstances that's the case. But most of the time they make too much money, and their finances are such that they have cash crunches, but they make enough to pay people back something. And so the answer is sometimes they want to, but most of the time they have to.
So we have just a couple of examples here at the end of the presentation. As we've stated, if you have questions, go ahead and submit those as we're getting close to wrapping up here. But an example, if you are a secured creditor and you have a second mortgage on the debtor's residence, what do you want to do? You're likely going to want to contact counsel to review the plan, because especially if you have a second mortgage, the debtor in the Western District of Michigan can strip the mortgage if it's completely underwater and there's not a dollar of equity, just by stating so in the plan. In the Eastern District of Michigan and in other states, it can vary. The debtor is required to file what's called an adversary proceeding to strip that lien. But if you're in the Western District, that's not the case. So that's why you really want to pay close attention to the plan, especially if you have a second mortgage. If it is the principal residence, the U.S. Supreme Court has said as long as there's $1 of equity, the debtor cannot strip your mortgage or strip your lien. So as you can imagine, then it becomes a battle of experts in determining what is the value of that property. And you want to make sure you timely get your objections filed, so you should probably contact counsel for that. You're going to want to file a proof of claim, and we've already talked about the forms that are required for that.
All right, so we got a second question. And the second question is, who determines how much of a disposable income is left? Is that up to the filer, and how do you make sure that the information is truthful? Well, truthful is always a question. Remember that debtors swear and or affirm that everything in the schedules is true and accurate. So if they lie, there's a really big problem in the sense that their discharge might be denied. So somebody could say you lied in your schedules, so you're not going to get your discharge. So that's how you figure out whether it's truthful or not. They've got an obligation to do it. Also, they need to submit pay advices and other things that substantiate their income. It's not just on, on what they say. Remember, how do we determine disposable income? You take the person's income and then deduct from it the allowable expenses under the IRS guidelines. So it's supposed to be objective, meaning that there's something that everybody can look at to say their allowable expenses are within the IRS guidelines, so that gets to come out. It used to be that there were no guidelines, and you didn't use the IRS offer and compromise rules, and so that was always an issue, but now it's pretty much settled. And so to this end, remember, you've got a Chapter 13 trustee who does this all the time. That Chapter 13 trustee, generally speaking, reviews the plans to make sure that the income's right and calculated correctly. Somebody can have income that goes up and down, so usually the pay advices over a 6-month period are going to tell you exactly what that is. And then the trustee's looking at the allowable expenses, and you might think it below them, or they wouldn't bother to do it, but they are objecting to expenses. And so you can't rely on the Chapter 13 trustee to protect your interests, but there is another entity that's looking at these things.
And before we go into vehicle loan, I'll just recap a little bit on the second mortgage. We talked about the dollar of equity, and that's if it's a principal residence. I know in one instance we had a client where they had several mortgages on the debtor's rental properties. And so in that instance, the debtor was able to cram down, strip the mortgage down to the value of the property. So if the properties are underwater, then the debtor is going to be able to take the value of the property. Again, you may have a battle of experts on what the actual value is, and then cram the amount paid in the plan on those properties that are not the debtor's principal residence. So that's an instance when it's permissible to cram down. In a Chapter 13 for a vehicle loan, if you have a loan with a creditor that is secured by the vehicle, again, you should contact counsel to review the plan for you, and you're going to want to file the proof of claim early. You want to review whether the loan was given within 910 days of the debtor filing for bankruptcy relief, and the debt or the loan was for the purchase of the vehicle. If it was a refinance, the 910 rule doesn't apply. But what we often call the 910-day rule is if the car was purchased with 910 days and you lent that money, then the debtor cannot cram down the vehicle, the amount that's paid to you, to what the vehicle's value is, because we all know that, the old saying goes, you drive the car off the lot and it diminishes in value. Well, so the idea is that even though that vehicle is diminishing in value, you're still going to be paid in full as long as that car was purchased within 910 days. And this is a common tactic or ploy, if you will, that debtors will do, and they're hoping you're not paying attention. So you have to look at the plan and make sure that the debtor hasn't tried to cram down your loan, because that's an easy objection and that's an easy win for you to be able to get the full amount that you're owed on that claim.
Okay, so why is that? Why is there a 910 rule? That's kind of an interesting thing. And why do you come up with the 910 days, and why do you come up with $167 of disposable income? That makes no sense to anybody, right? Okay, so here's the reason why. It's because a bunch of legislators negotiated over this, and those were the numbers that they came up with, the compromise, right? You have somebody that says, I want it 900, I want it 920, and they settle on 910. I wanted 160, and the other guy says 173, and we settled on 167. So it's all compromised with Congress. Now, the bigger question is for the 910 rule is this. 2005 was when the Bankruptcy Code was amended last. There's a lot of controversy surrounding that amendment because people said that people were defrauding the bankruptcy system. It turns out that generally is not true. It turns out the credit card companies lobbied Congress for about $5 billion for the purpose of delaying people filing their bankruptcy petitions, and then ultimately it ended up being a benefit to credit card companies of about $15 to $20 billion, depending on how you calculate it. So not everything is always altruistic. There's a reason for everything. Remember, follow the money. So part of the revisions in 2005 those revisions were also lobbied by big businesses. Some of those big businesses are GMAC Finance, Ford Motor Credit, Honda Finance. And what did they say? We're sick of people filing Chapter 13 cases, and the first thing they do is strip our lien. Remember, because you can do that in any bankruptcy case. You can strip the value of the lien down to the value of the collateral. So especially with vehicles, you go, the moment I drive it off the lot, it's worth a hell of a lot less than I just paid for it. So if I buy a car and then I file Chapter 13, I can strip the lien, pay less, and move on. Well, of course, Ford Motor Credit and all these big creditors got sick and tired of it. They went to their congressmen and senators, and you come up with the 910 rule, which says, okay, if you buy a car from GMAC, or it gets assigned to whatever credit union or whoever the lender is, if you bought it within 910 days, which is what, just short of 4 years or something, just short of 3 years, then you can't strip the lien. And so it was invoked, this rule, to protect people making vehicle loans. That's the deal.
Yeah, and it's important to note that, we say this is impermissible and the 910 rule prohibits it, but it still requires an objection to the plan. So unfortunately for you, it's an easy win, and it probably doesn't require your counsel to attend a hearing, but the objection still needs to be filed. And sometimes it's even just contacting opposing counsel and saying, what did you do here? We know full well that you can't do that. We're going to file an objection, get it changed, and they may do so voluntarily. But a lot of times it requires an objection. They amend it. You don't have to pay counsel to go to a hearing, but don't let that slip by. Our last example is when you have an unsecured claim. An example that we have here is a guarantee. You file that proof of claim, as we talked about, automatically. And if your claim is very high, you may contact counsel to review schedules, the statements, and the proposed plan to make sure that the debtor truly qualifies for 13, number one, and number two, that the debtor is surrendering all disposable income into the plan, like we talked about, to make sure that those expenses aren't unreasonably high, that they aren't, having 2 or 3 different vacation properties and RVs and all of these things that we consider to be luxury items that the debtor shouldn't be able to have while not paying their creditors. So keep in mind that bankruptcy is designed for the good and honest debtor. So there are times that it may be worthwhile filing an objection to make sure that the debtor pays in all disposable income. And while you do have to share that with all unsecured creditors, if you're taking the percentage of payout from 10% to 50%, that's still 50% of your claim.
So remember one thing. We might have gone over this in the Chapter 7 rules, but bankruptcy is a court of equity. It means that the court is doing what is right and just, at least under the bankruptcy code. So when you go to bankruptcy court, you don't get a judgment. You don't get order for money. What you get is a discharge for debtors. And so in exchange for the discharge, there are rules. There's rules under the bankruptcy code, but generally the principles of equity say you have to be honest, forthright, and do what you say you're going to do. So those are some of the protections that are built into the system, which is if the court's going to give you a discharge, you have to be straightforward and stand up debtor. And I think that's all.
Well, I have one last thing here that I didn't mention that we could object when you have an unsecured claim, because I think generally people think, all is lost if you have an unsecured claim and somebody files bankruptcy, but especially in a 13, that's just not the case. Like I said, maybe all of the disposable income isn't being paid in. But another area that can be affected is if the debtor filed a 36-month plan and it should have been a 60-month plan. If you now add 2 more years onto, if it's $500 a month that's being paid in, like Scott said, that's a substantial amount of money. So that's something that should also be reviewed, and it might be another way to get more money out of the bankruptcy case. And so just keep in mind, just a couple of notes for post-discharge. After that Chapter 13 is completed and the debtor receives the discharge, you can never go back and collect that debt. So just make sure that you're aware of that. And once the debtor does receive the discharge, as we stated, you can go after the non-filing co-debtor if you haven't already been paid in full.
Just be careful here, because we just had a case where our client collected a debt. It wasn't in bankruptcy, but they collected the debt, and then through one malfunction in their system or another, it showed that they still owed money. They sent it to a collection agency, and the collection agency attempted to collect a debt that had already been paid, and our client got sued in federal district court, and as a result, somebody's paying some money. So be careful there. We did get another question. Okay, hang on a second. The question is, I'll just read it verbatim. What happens with credit card debt in both chapters? Say you go out and max out your credit cards right before filing. Is that still charged off? We had a customer that purchased a large amount of product and then filed for Chapter 7. Do they get to keep everything for free then? Okay, so credit card debt is unsecured debt. Unless you're K Jewelers or somebody like that takes a security interest in what they sold, you're an unsecured creditor. So the answer is, generally speaking, unsecured debt, credit card debt, is discharged in a Chapter 13 and a Chapter 7 case. There are provisions under the bankruptcy code that allow for a non-dischargeable debt to occur. In other words, it won't be dischargeable if within 90 days of filing the expenditures are what might be termed to be luxury goods. So you have to look at what it was spent on to determine whether or not it's going to be discharged. Now that requires an adversary proceeding, and those can get expensive, so it depends on the nature and extent of how much they ran up the credit cards on. This one said, we had a customer that purchased a large amount of product and then filed for Chapter 7. Do they get to keep everything for free? So I guess I'm not following that. We had a customer that purchased a large amount of product. Now, if a customer purchased product from a creditor and then filed a Chapter 7 case, depending on the nature and extent of the product, it could be that it's subject to Michigan's statute on the Michigan Builders Trust Fund. I don't know where this creditor is from, but if it's for building materials or something that's incorporated into a building, Michigan's one of the few states that has this thing called a Michigan Builders Trust Fund Act, and that says that if you provide goods or services to a building or builder and they get paid from the owner, then there's a trust fund created on that money. Then they have to turn around and pay it to you. If they don't, then they can be held personally liable even though they have a corporation. So it's a very strong statute. It's kind of hard to prove, but in the circumstance where there are building materials, construction materials, that can be the case. Also, and Trish just wrote me a note, under the bankruptcy code, certain things that are provided pre-petition can also be subject to what's called a reclamation action. In other words, if you give credit to somebody and they turn around and file a bankruptcy case, you can say to that person or entity, hey, by the way, we gave, I think it's 45 days?
I think it's 20.
And that's 20, okay, you're right, 20 days. Within 20 days of filing, anything that we gave you on credit, you have to actually give it back to us. You can't just keep it. So do they get to keep everything for free? If it's within 20 days, you can make a reclamation demand, they have to return it to you. If they ran up the credit card debts and it's luxury items, you can go ahead and sue them on that as well. So there are remedies under these circumstances. They're very fact specific. In other words, you need a lawyer to look at it and say yes or no. In other words, we can go after them, we can't. And then always in those circumstances, you have to weigh the cost of moving forward against letting it go. Because, you know, lawyers get expensive.
They do, but it is an answer that can easily be provided. You know, we keep saying contact counsel. Well, it's not difficult. You explain your situation to us, and we can tell you, you know, very quickly whether or not it's worth pursuing. Of course, it's your ultimate decision, business decision on whether it's something you want to pursue. But you can explain those facts, and it's something that we can determine. But you know, just keep in mind that all is not always lost just because somebody filed for bankruptcy relief.
Okay.
And I think that's a wrap.
All right, thank you. Thanks for attending.